The CPI report, Child Protection in Iowa, brought to you by Vocal, Victims of Child Abuse Laws. You can watch our program on Mediacom Channel 15, Sunday afternoon at 1 o'clock. Also on Wednesday evening at 9:30. You can email us at vocaliowa@mchsi.com. My number is 515-276-3956. And John's number in Des Moines also is 515-282-2672. My name is Don Burgmaier, and with me at the controls is my co-host,
John Harvey, and welcome to the CPI report. CPI, that stands for Child Protection in Iowa. It has two major areas of tasks that we work with. One of them is to influence public policy as it relates to child protection issues, and secondly, we do the interaction with parents who call upon our expertise in the area. We like to work one-to-one, one-on-one with parents, and I think we've reported earlier that we had one young man who wasn't even a parent, but it doesn't require that you be a parent for the DHS to jump on you, and they jumped on him because he was an older foster child in the home. And when he followed some of the basic things that we gave to him, he won his case in the evidentiary hearing. Now, the evidentiary hearing is a administrative hearing, but it's about the only chance that you get to have your story properly told before a hearing officer or before a trier of fact. And it's about the only time that you get an opportunity to get anything into the record. After that, it's only the record that they look at when you want to revise or to overturn a founded report from the Department of Human Services. Well, if we have time, we can talk about that later on in the program. We want people to resist those reports. Get them corrected. There's no reason why you should have to have a report that is adverse to your interests. Reports of child abuse may not seem all that terrible in written form. However, if you realize how extensive they can be in their in the way they use those reports, you can lose your job, you can lose your profession, they can pull your license, they can do all kinds of things if they have a child abuse report against you. And I even see that on employment applications now. Have you ever had a founded child abuse case against you? You know, if you want to be a restaurant manager, well, there's sometimes patrons in the restaurant that are under 18, and they don't want people around that the insurance company says, we're not going to insure you, you know, if you have people working for you because there's likely to be children in the building at one time or another. Well, they do all kinds of strange things that aren't even found in the law, and we're going to be talking a little bit about that. Our legislature has been doing all kinds of strange things, and I look at the list of enrolled bills, and I can't find anything that really would enhance the family as such. I found one bill that requires that children be tested for lead, and that they also, before they go to school, must have a dental examination. I don't know when that takes. I don't know the effective date of that, but it's called an enrolled bill. In other words, it's gone through both houses. I don't know whether it's been signed by the governor yet or not. But they've come up with some very strange things for children. In one case, there's a bill out about fingerprinting children. Obviously, this is not a mandatory one, but fingerprinting children, you know, it seems like they use this tactic to uh, get a hold of children for one reason or another, and I don't know why, because fingerprinting serves only one real good only one purpose. I'm not even sure it's a good purpose. Uh, it helps the officials identify the corpse. Now, what in the world would you want to saddle a child down with getting fingerprints when he's little to identify the corpse? Well, I'm not sure that would be a satisfactory resolution to all the problems that we have with children, in my opinion. Let's turn now a little bit to that first issue we talked about, and that is perhaps we should have a study commission by the General Assembly. This has been a year for new study commissions created by the Iowa General Assembly. Here's how petty they can be with respect to development of a study committee. If we don't know what to do with cans and bottles, we form a big commission and include all parties. This can be very costly on items as insignificant as the bottle bill, which is already before us in law. By contrast, a far more meaningful need lies before us. You know, when they're stealing your children, that's far more meaningful than how we deal with cans and bottles. But there exists no significant, comprehensive drive to improve the way we intervene into families and to care for abused children. Children are being removed from their homes while investigations are taking place to see if the children should be removed. In other words, they devastate the home first, tear it apart, to see if there's anything in that home that would substantiate the actions that they just got through taking. In one case, 3 children were removed for 87 days to find out if broken bones were the result of parental abuse. No one bothered to investigate first, then remove only if necessary. The human cost in lives of the toddlers is enormous. The cost of investigation based upon unsupported assumption and fallacious reasoning is extensive. The cost to parents to take off time from work to engage in hoops such as counseling and therapy and family team meetings, in addition to time taken to appear in court hearings, is unusually taxing. I don't know how they figure that helps protect children, to disrupt the family first so that they can do all this investigation at their leisure. Now, how silly is that? The cost to parents also can include the cost of services. In other words, they can turn around and tell you that you've got to engage in a certain service. And if you don't have insurance to cover it, that's all right, because you can cover it out of your own pocket. And the cost of an attorney who will do your work in court. And there are times in which all of this was accomplished without any sort of logical or reasonable basis. In all other parts of law, particularly in criminal misdemeanors and so forth, they have to have a signed affidavit of some kind of complaint. In child abuse, no signed affidavit. No one has to step forward and say, I'm the accuser. I'm the one who has the objective knowledge that a child has been abused. They don't really care for that kind of basis. How does that type of thing protect children? It only sets about to destroy and disrupt an otherwise normal family. Can we expect workers to have the wisdom of King Solomon? The answer is definitely no. However, we must have a definite scheme or protocol that must be followed. In the meantime, we must agree that as imperfect people, we will not always make every decision correctly. There may be children who die as a result of our decision. But if we're following a certain pattern of protocol that is carefully supervised and updated from time to time, that cost should be, or that possibility of making an error should be minimized. We'll never get to the point, so long as it's humans staffing the Department of Human Services, that we will have a perfect record. There will be losses no matter what kind of system we operate under. I would far rather have a system operated under a systematized business-like protocol than the flip of the coin or the guesswork of a new hire just out of the University of Iowa. The best hope of a successful mission is to know just how we are going to follow the dictates of statute in a business-like manner. It is obvious that the DHS has agendas which are not in keeping with the intent of the law under which the DHS is operating. It would seem like to me that we keep using the word accountable, but I think there are better terms, that there ought to be some kind of a link between what they're told to do by the General Assembly and what they're actually doing. And if their agenda is to increase their staff, is to increase their influence, and to get into all kinds of other activities that is not directed by, specifically directed by the General Assembly, we shouldn't pay for that sort of stuff. And we shouldn't tolerate the errors that arise from conduct which is not of a business-like nature. Let's look at it this way. There is a great model to follow, and that is what controls our vast system of air traffic. The FAA, Federal Aviation Agency, has rules that includes about every imaginable element of flight, including flight training, licensure, aircraft mechanic certification, aircraft radio, traffic control processes, and many other areas. Those rules are updated from time to time and supervised constantly. It is anticipated that if a flight takes off, it will sooner or later land. Those rules are updated from time to time, and in the case where there is a mishap, the NTSB, the National Transportation and Safety Board, steps in, and they have all kinds of rules. Back to that area about the aircraft taking off and landing. In case there is a mishap, this is called an unscheduled landing. So anytime there is a crash, they think of it as an unscheduled landing. All information is gathered by the NTSB, examined, and reported. Usually they're able to make a determination about causation of the mishap. It might be that the pilot was drunk, or that he hadn't had enough sleep, or that he was new on the job and hadn't had sufficient training for the aircraft that he's operating on. Many of these causations relate to what they call pilot error. Other errors can be wiring that runs through the gas tank, maybe mechanical errors, and if those are tied down, they are reported, and in some cases there are aircraft that are grounded as a result. If there's a mechanical malady, the NTSB can ground aircraft of the same make if there is reason to believe that flight safety would otherwise be compromised. What's wrong with using this kind of a model in dealing with the critical issues of child protection and intervention. There should be no intervention into a family unless there is a mighty good probable cause to intervene. We're going to talk about some of the other cases that they deal with, and I think they deal with it in order to gain a large number of cases. I don't think they deal with it because of the fact that it's necessary for one reason or another to deal with these insignificant cases. I call it majoring on the minors. Social workers can operate outside of any set of rules or practice as long as the supervisor permits it. So as long as your supervisor lets you do it, there's no problem. When there's no clear indication they have any regard for the privacy of a family or the difficulties that are imposed by intervention. They don't care if you have to quit your job. And I've told on this program a number of times cases where a fella had to attend so many meetings that his boss called him in. He worked for the railroad. His boss called him in and said, "You've been a good employee for a number of years, but we cannot permit you to take so much time off." So he turns out to be a sandwich maker for one of the subway organizations. You don't make as much money as a sandwich maker as you do working on the railroad. So here is where the Department of Human Services came in and rearranged his life for him with a significant disadvantage. I don't know how, using that kind of reasoning, that we can say that that it's good protection for a child if it requires that kind of behavior on the part of the Department of Human Services. They also do such things as counsel people to divorce their spouses. I've also heard them say, well, because there is an allegation that of child abuse here relating to the father, don't let the children have visitation this weekend. Excuse me, that makes the social worker part of the contempt of court. And I think they should be held in contempt of court along with the spouse that withholds visitation from the other spouse without probable cause. If there's probable cause, go to court, get a court order, and let the judge decide in such things as this. I don't think that those kinds of things should be a part of the vocabulary of a social worker. I don't think that statute envisioned that social workers were to go out and do things that were far outside their job description. I don't see how that enhances protection for children. And it certainly doesn't give a clear indication that there is a solid linkage between what the General Assembly calls for in statute and what the DHS is actually performing at $2.3 billion in costs. You see, this organization is a gigantic organization, and they operate primarily in secrecy. Well, we said that there's no clear indication that they have any regard for privacy or the difficulties that are imposed by intervention. One of the worst parts is that DHS tends to dwell on the minors rather than to assist in major problem areas. That, together with the guest-based casework, we have a system that is totally out of control and a potential hazard to Iowa families. A citizen group should be commissioned to explore all issues of conduct of the DHS. I think that we could do a better job of protecting children, and I think we could do it at a lower cost and fewer staff members. You see, there were errors made, and it'd be interesting to know what the DHS says about the errors that were made in Waterloo that resulted recently in the death of a child. when the record pretty clearly showed that that child should not have been returned to the home. You see, in some cases, they'll return children to homes where there is where the record shows that there is a clear-cut reason for not doing so. In other cases, um, they'll they'll remove children who shouldn't be removed, and we mentioned that with the three toddlers that were removed from their home for 87 days, and that causes a lot of difficulty. In one case, and Don knows about this case from Harlan, Iowa, um, a little child was removed from her mother's care, placed in foster care. The neighbors, the friends, the relatives of the child, the foster parents counseled them not to return the child to the mother because the mother would kill the child. Candace Lambie was a social worker looking for a promotion, and she decided on her own, without seeking counsel from anyone else, and without following a decent protocol, returned the child to her mother, who in turn killed the child. How does that protect children when social workers are permitted to do their own thing without any kind of a rational basis for doing it? Well, I think that the kinds of things we can say, well, that was in the past. Well, I want to see what improvements the DHS has taken to prevent social workers going out on their own, doing whatever they please, and jeopardizing the safety of children. When they remove children that shouldn't be removed and cause disaster, when they put children, when the record shows clearly that their safety would be compromised, they put them back in the home. I'm not sure that they know what they're doing. A citizen group should be commissioned to explore all these areas, and there should be a performance audit run to determine if the conduct of the department has any relationship to the intent of the statutes put in place by the General Assembly. Example of seized problems seized by the DHS and turned into founded reports. Well, here's a mother that leaves a baby in the car while taking cans into a convenience store for redemption. And not only the social workers jump in on this, but the police jump in on this. I don't know how they got the car unlocked because the mother locked the car, but they took the baby to the police station. The baby was asleep at the time that the mother left the child, and she said she was only gone for a few minutes. She wasn't there at the convenience store to do any shopping. She just wanted to redeem a large bag of cans. Perhaps we ought to look at that can law and see if she couldn't just dump those in a green bin outside of the convenience store and drop the whole notion of deposits. But that doesn't excuse the department from intervening in this case. And Don has a similar one that he's going to cover here in just a moment. A 19-month-old toddler in Winterset, whenever her aunt comes to visit, goes out and jumps in the van and is proud to sit in the back seat of her aunt's automobile or her van. Well, a social worker came along and decided that was child abuse. How do you call that child abuse? She's on their own property in a vehicle owned by a relative, and somehow, because they need the cases, and somehow their jobs would be jeopardized if they didn't have the right number of cases to justify their jobs, and they have to, here again, major on a minor. Time after time, not only children left in automobiles, but bruises and scratches and everything else which come with children. I don't know of any child that has made it through toddlerhood without bruises and cuts and burns and everything else. It's just a part of childhood to come with those kinds of things. I thought I had some information here with respect to the NTSB, but we'll look at that. And here it is. There are rules if your aircraft has an unscheduled landing. You're supposed to report that to NTSB.
What is the NTSB?
That's the one I named earlier. That's the National Transportation and Safety Board. And I point to them as and other. See, that's one of the more successful agencies we have in government. Not all agencies in government are all that helpful, but at least they have some kind of an idea of what they're doing. There are hundreds and hundreds of flights taking off every hour. Hundreds and hundreds of flights land successfully and are guided to their destination successfully, largely because of the fact that there are rules in place to assure the safety of these aircrafts. And not only the equipment itself, but the personnel, the licensing, the training of the personnel. And I still don't have the... here's a report, for an example. NTSB report. And this was a landing roll, it's called, phase of the operation. A thrust reverser was inadequate. Procedure and directions not followed by the flight crew. A lack of familiarity with the flight. That was a problem of the flight crew. Procedure inadequate. Condition step insufficiently defined. That's a part of the company operator management problem. You see, they go through and examine each of those problems, and if instead of creating a system whereby we set up a different investigation for everything that happens. When Shelby Dewis died in Dickinson County, Spirit Lake, Iowa, they commissioned a $140,000 study to study that. Well, those studies should already be in place and acted upon immediately upon the death of a child or upon any incident which compromises the safety of the child, or an incident which falls outside of the boundaries of the Department of Human Services. Should be just like the NTSB. Whenever there is an unscheduled landing, that should be reported and studied. And if it is a problem in which the rules were inadequate, then we change the rules. If it's a problem with operator error, which in this case would be a social worker or a therapist or somebody else who's contributing to a disaster, let's make sure that we know what we're doing in these cases. And in the cases where there are some mishaps, let's have it already down set up so that we can study those mishaps, improve the protocol, improve the training, or whatever the problem happens to be. And if it happens to be that we replace the person who doesn't know how to follow rules, replace that person. There should be no real problem about following a model that is patterned after the FAA and this National Transportation Safety Board rules. One which controls a flight, one which investigates if the flight is terminated inappropriately, such as a bad landing or a crash landing, in which there may or may not be fatalities. There may or may not be pilot error. There may or may not be weather conditions that are inadequate or bad field lighting. But they search out what the problem was. They don't leave anything up as information that may be necessary for such a study committee to operate. But indeed, we need people who have been there, who have been devastated by the department, can testify to where the department has gone wrong. In the meantime, let's listen to one story about a case where a situation was studied, not in Iowa in this particular case, but it was a similar a case similar to Iowa's cases where the social workers have been majoring on minors, and there's only one reason to major on a minor, and that's to keep tabs, or to keep the social worker in his position or her position. Because if they don't have enough cases, there's no reason to have them around on the budget or on the payroll. Don?
Okay, John. This article was written in March of this year, just recently. This woman is from Tingley Park, Illinois. She's 36 years old, and the article said she is scheduled to stand trial on misdemeanor child endangerment and obstruction of justice charges. And then the article goes on and says, charges against Chicago mom dropped. Well, I'm sure she's happy after the end result come through. The charges against the mom who left her child in the car, but hardly unattended, have been dropped because prosecutors could not meet the burden of proof. In other words, they couldn't convince the judge with the facts that they had that she was guilty. Naturally, the police department is standing behind the arresting officer. Police do no wrong. The final sentence of the article, she said she was afraid and only wanted to wait for her husband, but police arrested her before he did. Well, that was a error on the writer's part. I think what the writer was trying to get across is that the police arrested this wife before her husband got on the scene. The wife had called him on the cell phone, and he came there before I think they even left the scene. It wasn't that that her husband was arresting her; that was the police that was arresting her. The article goes on. Mom faces trial for leaving toddler in car. Controversial child endangerment case stirs internet debate. So there was a lot of talk on the internet about this issue. Triffy was out of her car for just minutes and no more than 10 yards away. But that was long and far enough to land her in court after a police officer spotted her sleeping 2-year-old daughter alone in the vehicle. The mom had taken her 2 daughters to pour $8.29 in coins into a Salvation Army kettle. A lot of people do that. Okay, it says minutes later, after she dropped the coins in, she was under arrest. The focus of both a police investigation and a probe by the state's child welfare agency. Now the case has become an internet flashpoint for people who either blast police for overstepping their authority or the mother for putting a child in danger. So there's always people out there that believe that parents should be doing more to protect their children. The 36-year-old suburban mother is preparing to go on trial Thursday Now this is after the fact, because we know that the court found her innocent now. She went on trial Thursday on misdemeanor charges of child endangerment and obstructing a police officer. If convicted, she could be sentenced to a year in jail and fined $2,500, even though child welfare workers found no credible evidence of abuse or neglect. Well, that's a good thing, John, that after the DHS investigated, they dropped the charges there. On December 8th, the mother decided to drive to Walmart in the Chicago suburbs of Crestwood so her children and a young friend could donate the coins they'd collected at her husband's office. Even as she buckled her 2-year-old into the car, the girl was asleep. When the mother arrived at the store, she found a spot to park in a loading zone, right behind someone tying a Christmas tree onto a car. It's sleeting out. It's not pleasant. I don't want to disturb her. Wake her up, the mother said this week. So, excuse me, it was a miserable day out there with it sleeting. And why drag a child out into that when she'd be safe in the car? Mom goes on to say it was safer to leave her in the safety and warmth of the alarmed car than take her. In other words, if somebody tried to break in to her vehicle, the alarm would go off, and everybody around would know something had happened, including the police that were walking by, including Mom, who was just a few feet away. So Mom switched on the emergency flashers, locked the car, activated the alarm, and walked the other children to the bell ringer. What more can a parent do? She snapped a few pictures of girls donating money and headed back to the car, but a community service officer blocked her way. She was on a tirade. She was yelling at me, the mother said. In other words, it was a woman officer yelling at this mother when she noticed a child in the car. The officer, the mother said, didn't want to hear about how close the daughter was, how she never set foot inside the store and was just there to let the kids donate money, or how she could always see her car. Mom telephoned her husband, Tim, who advised her not to say anything else to the police until he arrived. I think that was good advice. So Mom declined to talk further. She refused to talk to the police at that point. That ticks the police off. They want you to talk. Social workers want you to talk. That'll get you in trouble. You're talking. Mom refused to tell police her child's name. When the husband pulled up, his wife already was in handcuffs sitting in a patrol car. Police chief declined to comment about the case, but he did not dispute the contention that the child was parked nearby, or was no, it was the mother. He did not dispute the fact that the mother parked nearby or was away from her car for just a few minutes. He didn't dispute any of that. He did, however, suggest the mother put her child at risk. Well, how many parents do put their child at risk? We don't have the jails big enough to hold every family in the world, let alone the DHS workers. How about putting a DHS worker into jail that puts our children at risk? And there's plenty of that going on. Okay, the article says, online debate. Talk about the cases has intensified, particularly online. Many have harsh words for the police department, calling the arrest of a mother who left her child in a locked car for a few minutes an abuse of authority. Yet statistics show thousands of children are injured and dozens die every year after being left unattended near or inside vehicles. I don't know about thousands. That sounds like a pretty big number. But there are accidents happen. But you can't send a parent to prison and expect to stop all the problems. Um, the mother and her husband believe she is unfairly being lumped in with parents who put their children's lives at risk. If I were going on a shopping spree, then yes, I would deserve arrest, the mother said. I was standing right there. I never went into the store. Okay, John, I'll turn it back over to you.
Okay. Thank you, Don. That's just one of many, many examples. I had one of them where the father took 3 children. They were playing out in the snow. Took them with them to visit the Target store. The children decided they would stay in the car instead of going with Dad. They were perfectly satisfied with doing that, and the social worker came by and said, well, he couldn't do that because they would freeze out there in the car. It was 26 degrees. That was the same temperature they were playing in at home. But being in a car, that was somehow a disaster. So mother went in to pick up pizza. The car was just outside the plate glass window. The social worker called it child abuse. Well, these are the kinds of things that happen when you leave social workers to do whatever they please, with no protocol, no standards, none of this sort of thing. Just go out there and write up the cases and run up the bills for the court dockets and everything else. Don't worry that you're devastating the public and you're picking millions of dollars out of the public till that should be there for other purposes. I want to tell you about a gentleman that looks at the courts and looks at them circumspectly. He wants those courts to run in accordance with the Constitution and to run in accordance with the rule of law. And when they don't, and when the judges misbehave, there is a fellow by the name of Terrance Walker who is a self-appointed judge of the judges. I'd like for you to hear now from Terrance Walker.
Well, thanks a lot, John. You always give me a great introduction, and I just had a quick riddle for you. How many judges can a judge if a judge could judge judges? Just thought I'd throw that out there. Got to keep it light sometimes, because we deal with a very deep and heavy subject, which is the justice system in the United States of America. And one of the underpinnings, one of the foundations of the justice system here in the United States is that it provides equal justice for all. And in that vein, I would like to highlight a story. Well, it's a lot of lights here. I'd like to highlight a story that I think would, cast a judge here, a local judge here, matter of fact, right here in Des Moines, Iowa, in a positive light. I always come up against and say things critical of the judges here and the justice system as a whole. Those things need to be said, but also there's some positive things that need to be said. And this one would be Judge Joe Smith, right here in Des Moines, Iowa, Polk County judge. And I do have a good story reported about him by Dana Boone with the Iowa Independent at iowaindependent.com, which was printed on April 3rd. You can actually look at the article online at iowaindependent.com. Really good website. Judge Joe Smith, and I've got a picture of him, by the way, if you want to highlight that. Juror sees racial injustice in Iowa courts. Lady Justice wears a blindfold to signify that justice is supposed to be blind, but in Iowa, her blindfold is askew, and that's a bad thing for people of color. Unequal treatment for minorities, especially blacks, can be found at nearly every decision-making point within Iowa's criminal justice and child welfare systems. Decisions that, if tainted with prejudice, can mean jail or prison, foster care, or termination of parental rights. It's not happening by accident. Polk County Assistant or Associate Judge Joe Smith, says he knows why it's happening and he recognizes the culprits. It's a rather surprising answer. And he's quoted as saying, "I think we as white people are responsible for it," he said. Many white people still equate racism and being racist with the KKK and burning crosses, he said, but it's the everyday decisions being made throughout the systems that are problematic. The institution is imposing a result that is distinctly racist, Smith said. State agencies, researchers, and others have long studied the issues of racial disproportionality that are rampant in schools, prisons, and the child welfare system, as well as the criminal justice system. But Smith contends few want to examine the root causes. And that's something that we share every week on this show. Look at how long there have been sentencing structures in place that have had a disparate impact on people of color, he said. It's decades, and we've done nothing about it. Smith, a former public defender who has been a judge since 1999, didn't wake up one day and decide to confront racial bias, but a 2.5-day Undoing Racism seminar by the Louisiana-based People's Institute for Survival and beyond jolted him out of his oblivion. During the seminar, which he has taken twice, Smith sat in a circle with people of different races who described the demeaning treatment they endure because of their skin color. They also talked about history and racial issues. And he says, "When I got home, I said to my wife, I'll never look at a black person the same way again. It was that profound. I never knew that there was so much I didn't know." And the Iowa Department of Human Services and the Institute are offering the free Undoing Racism seminars in Des Moines through June. The seminars, taken nearly by every juvenile court judge in Polk County, challenge him to study and speak out about the problems. They compelled him to consider his own actions, those of others, and change how he interacts with people on a daily basis. Recently, Smith had a case where a young black man was arrested for shoplifting in a Des Moines suburb and was placed in a detention center. And he's quoted as saying, "I know as well as I know my own name that if he was a white, they would have taken him down to the cop shop where they would have sat all night for the parents to get there, and they'd have fed him supper and given him a Coke. A little black boy gets hauled off to Meyer Hall and locked up. This is how racial disparities in the system can begin," he said. "It's not just institutional racism and prejudice, but white privilege kicking in there. As we know, detention is the surest predictor of future incarceration that we have," he said. "When children are detained, the chances that they wind up in prison go up significantly." As a public defender, he agreed with lawyers who dislike dealing with their black clients' mothers, wives, girlfriends, and aunts. Quite often, the black women were loud and aggressive and demanding, he said. He viewed their behavior as disrespectful. His colleagues told him the women drove them nuts. Now, when he's on the bench, he now thinks about the racial injustices that black women might have endured that could be motivating their behavior and the cultural differences that might be coming into play. "By the time they get to me, I may be the sixth person that they've dealt with, and they feel like they're being shoved around because of their color, and they may not or may not. The reality is it is not disrespectful for the institution, and it's not disrespect for me." He added, "This is the black woman trying to make herself heard in the only way she believes that Whitey will listen to her. They're trying to help the man in their life, and what's wrong with that? It's a shift in attitude, but it's not the only one Smith has made. He warns young blacks and Latinos in his courtroom about the perils of running from the police." And I'm going to skip some of this because we're running a little short on
that's
time.
All right. Go ahead.
Because we see so many African American women who are single mothers, mothers of children of more than one father, that we think those fathers somehow don't count, don't matter, that we don't need to consider them. These days, Smith said he pushes the Iowa Department of Human Services to consider the father and his family in cases where a child may need to be placed away from its mother. Smith also worked with Casey Family Programs, part of a national foundation that works on child welfare issues. The project is called Breakthrough Series Collaborative. It looked at the disproportionate number of children of color in the system. In Des Moines, more black children of color are referred to DHS than their percentage of the population. When it comes to adjudication, the percentage of black children adjudicated goes up. When it comes to removal, it goes up. When it comes to termination of parental rights, the percentage goes up, and they stay in foster care longer, and they're less likely to be adopted. In each stage of the proceeding, the results for children of color become more disappointing. Why do the results for people of color worsen as they advance through the system? Smith has a theory. It is because we bring a whole set of unconscious preconceptions with us make the decisions that we might not otherwise make. That influences us in a way that we make decisions that aren't really in the children's best interest, but we believe that they are. White people never think about their own skin color and race because they don't have to, he said, but they must begin to open their eyes in the role they play in causing the racial disparities in the systems in which they work and consider how the decisions they make affect people of color they interact with every day. That way, Lady Justice can't peek. And he's quoted at the end of the article, it just involves walking into the courtroom and looking at your family and seeing if it's a family of color and asking yourself, why am I doing what I'm doing? And I think we do need to applaud Judge Joe Smith because he is one of the few, unlike our Iowa Supreme Court chief of the Supreme Court.
Yeah.
Okay. Marcia Terrance, who tended to ignore this very real problem here in Iowa court systems, which is the disparity that goes on not only in the DHS and the child welfare system, but also the criminal justice system as well. So we have a district associate judge that's willing to go out and not only speak about the issue, but not only that, but take it upon himself to do something about it. I do think that's very highly commendable, and I think we do need to applaud him. And definitely don't vote no on Joe Smith when it comes time for election. When we do the retention vote to vote the judges out or in, we want to keep Judge Joe Smith around because he's one of the good ones. One other story, since we do have a little bit of time, I did want to highlight. We always talk about homeschooling, and I usually talk about the judiciary. Well, here's a story which pertains to both. We always talk about how the two interact with each other, and how if the judiciary isn't in line, then we really will not be able to keep the DHS officials in line as well. And this story comes out of the Pueblo Chieftain at chieftain.com, dated April 2nd of 2008. A California court ruling that homeschooling is unconstitutional is one of the latest palace coups coming out of the nation's judiciary. A Southern California couple, Philip and Mary Long, were homeschooling their children through a program at a Christian school. Such schools and homeschooling organizations provide curricula for parents to follow, and most avail themselves of these aids. Now, the family came to attention of the L.A. County social workers when one of the children claimed the father physically abused them. An attorney representing the two children, the youngest ones, that is, asked one of the juvenile dependency courts, asked them to basically have them children enrolled into public schools. They were previously being homeschooled. Now, Justice Walter Krosky ruled that parents who educate their children at home without a state teacher certification could be criminally liable under California law because parents do not have a constitutional right to homeschool their children, he said. According to the decision, the homeschooling children were receiving lousy, meager, and bad homeschooling. In another setting, the judge could have ruled that the kids in the public schools receive education that is lousy, meager, and bad as well. In many cases, that's precisely why parents choose to homeschool their kids. Homeschool kids are often perform high on standardized tests. Colleges recruit them because of their high SAT scores, and a number of kids who compete in the National Spelling Bee and other similar venues do exceptionally well as well. Now, this isn't the first time homeschooling has come under assault. In 1994, the federal government attempted to mandate certification of homeschooling parents until hundreds of thousands of calls inundated switchboards on Capitol Hill in protest. Now, the Long's case brought a delight to the California Teachers Association, homeschooling like charter and private schools cut into teachers' unions' monopoly. Of course, that's going to affect their pocketbook as more people tend to want to do this. But the extra commentary I would like to add to this article is that under landmark case versus Santosky versus Kramer, it would appear to me that there was a principle laid forth in that case that that parents have a fundamental liberty interest in the care, custody, and management of their children. Now, I don't know if there's been any specific case where they actually laid forth that homeschooling is something that's constitutionally protected, but it would appear under that precedent, under that principle, that as it pertains to the care, custody, and management of children, that the government shouldn't have a say-so whether or not you should homeschool your kid. And I would add that it would be criminal if parents would be subject to criminal behavior because they want to choose to homeschool their kids. But that's all I had, and I do want to leave the balance of my time to you, since you are the man of the show here. You always give me a good introduction. This guy is the man of the show here. He's the producer, commentator. He does everything. Works 4 or 5 different cameras. So back to you, John.
Punches up a few switches from time to time. If you're interested in doing something that would really be helpful, not only to homeschoolers but to others, you might want to look up www.parentalrights.org. Parentalrights.org. That is an effort to bring about a constitutional amendment which would assure that you're not going to lose your rights as a parent to the care, custody, and control of your children. This is an effort on the part of the Homeschool Legal Defense Association, who got in the business of protecting parents' legal rights to homeschool. They didn't realize they were going to get into the child abuse industry, but I'm glad that they're there, and I'm glad that they're fighting. They've built a school, Patrick Henry College, to train young men and women who come from homeschools and are doing a magnificent job. If you're interested in homeschool, you might want to check in with an organization called Niche, Network of Iowa Christian Home Educators. They will have a conference that you can attend and get a taste of what it would be like if you had an opportunity to homeschool your children. Here are some numbers that may be helpful to you if you're having a problem with the Department of Human Services. We'll see you next